Rule 112 Criminal Investigation Section 1 Criminal investigation define when required. Preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial, except as provided in Section 7 of the rule. Preliminary investigation is required to be conducted before the filing of the complaint or information for an offense where the penalty prescribed by law is at least for 4 years, 2 years and 1 day without regard to the fine. Section 2 officers authorized to conduct preliminary investigation. The following may conduct preliminary investigation: A. Provincial or city prosecutors and their assistants. B. Judge of the municipal trial courts and municipal circuit trial courts. C. National and regional safe prosecutor and 4. Other officers as may be authorized by law. Their authority to conduct preliminary investigation shall include all crimes cognizable by the proper court in their respective territorial jurisdictions. Section 3 Procedure. The preliminary investigation shall be conducted in the following manner. A. The complaint shall state the address of the respondent and shall be accompanied by the affidavits of the complainant and his witnesses, as well as other supporting documents to establish probable cause. They shall be in such number of copies as there are respondents, plus 2 copies is the official file. The affidavit shall be subscribed and sworn to be before any prosecutor or government official authorized to administer oath, or in their absence or unavailability before a notary public, each of whom must certify that the personally examine the complainant's affiance and that he is affiance the respondent shall have the right to examine the evidence submitted by the complainant which he may not have been furnished, and to copy them at his response. Copy response. On copy response, if his evidence is voluminous, the complainant may be required to specify those who who he intends to present against the respondent, and there shall be made available for examination or copying by the respondent at his expense. Objects as evidence and need not be furnished a party, but shall be make available for examination copying with 10 days from receipt of the subpoena with the complaint and supporting affidavits and documents. The respondents shall submit his counter affidavit at that of his witnesses and other supporting documents related upon. For his defense, the counter affidavits shall be subscribed and sworn to and certified as provided in paragraph of this section with couples thereof furnished by him to the complainant. The respondent shall not be allowed to file a motion to dismiss in lieu of counter affidavit. D. If the respondent cannot be subpoenaed or if subpoena does not submit counter affidavits within the 10 days period, the investigating office shall resolve the complaint based on the evidence presented by the complainant. So, E. The investigating officer may set a hearing of there are facts and issue to be classified from a party or a witness. The parties can be present at the hearing but without the right to examine or cross-examine. They may, however, submit to the investigating officer questions which may be asked to the party or witness concerned. The hearing shall be held within 10 days from examination of the counter affidavits and other documents or from the expiration of the period of their submission. It shall be terminated with 5 days. If within 10 days after investigation, this investigating officer shall determine whether or not there is sufficient ground to hold the respondent for trial. Section 4. Resolution of investigating prosecutor and its review. If the investigating prosecutor finds cause to hold the respondent for trial, he shall prepare the resolutions and information. He shall satisfy under oath the information's part, he or as shown by the record, an authorized officer has personally examined the complainant and his witnesses, that there is reasonable ground to believe that a crime has been committed and that the accused is probably guilty thereof, that the accused was informed of the complaint and of the evidence submitted against him, and that he was given an opportunity to submit controverting evidence. Otherwise, he shall recommend the dismissal of the complaint. Within 5 days from his resolutions, he shall forward the record of the case to the provincial or city uh, chief state prosecutor or to the ombudsman on his deputy in cases of offenses cognizable by the Sandigang Bayan in the exercise of its original jurisdiction. They shall act on resolutions within 10 days from the receipt thereof and shall immediately inform the parties of such action. No complaint or informations may be filed or dismissed by an investigating prosecutor without the prior written authority or approval of the provincial or city prosecutor or chief state prosecutor or the ombudsman of or his deputy. Where the investigating prosecutor recommends the dismissal of the complainant but his recommendation is disapproved by the provincial or city prosecutor or chief prosecutor or the ombudsman or his deputy on the ground that a probable cause exists, the latter may by himself file information against the respondent or direct another assistant prosecutor or its or prosecutor to do so without conducting another preliminary investigation. If upon possession by a proper party under such rules as the Department of Justice may prescribe or motu proprio, the Secretary of Justice reverses or modifies the resolution of the provincial or city prosecutor or chief state prosecutor, he shall direct the prosecutor concerned either to the file the corresponding informations without conducting under preliminary investigation or to dismiss or move the dismissal of the complaint or information with the notice to the parties. The same rule shall apply in preliminary investigation conducted by the officers of the Office of the Ombudsman. Section 5. Resolution of investigating judge and its review. Within 10 days after the preliminary investigation, the investigating judge shall transmit the resolutions of the case to the provincial or city prosecutor or to ombudsman of his deputy in cases of offenses cognizable by the Sandigang Bayan in the exercise of its original jurisdiction for appropriate action. The resolution shall state the findings of facts and the law supporting his action, together with the record of the case, which shall include the warrant if the arrest is by virtue of warrant. B. i.e. the warrant if the arrest is by virtue of warrant. B. the affidavits, counter affidavits, and the supporting evidence of the parties. C. the undertaking or bail of the accused and the order for his release. D. the transcripts of the proceeding during the preliminary investigation. And E. The order of cancellation of his bail bond if the resolution is for the dismissal of the complaint. Within 30 days from receipt of records, the provincial or city prosecutor or the ombudsman or his deputy, as this may, shall review the resolutions of the investigating judge on the existence of probable cause. The ruling shall expressly and clearly state the facts and the law on which it is based, and the parties shall be furnished with the copies thereof. They shall order the release of an accused who is detained if no probable cause is found against him. Section 6. When a warrant of arrest may issue. Warrant of arrest issue by the regional trial court within 10 days from the filing of the complaint or informations, the judge shall personally evaluate the resolutions of the prosecutor and its supporting evidence. He may immediately dismiss the case if the evidence on record clearly fails to establish probable cause. If he finds probable cause, he shall issue a warrant of arrest or uh, commitment order of the accused has already been arrested pursuant to a warrant issued by the judge. Section 7 of this rule. In this case of the existence of probable cause, the judge may order the prosecutor to present additional evidence within 5 days from notice, and the issue must be resolved by the court within 30 days from the filing of the complaint or information. B. The Municipal Trial Court. When required pursuant to the second paragraph of section of this rule, the preliminary investigation cases falling under the original jurisdiction of Metropolitan Trial Court, Municipal Trial Courts in cities, Municipal Trial Courts or Municipal Circuit Trial Courts may be conducted by either the judge or the prosecutor. When conducting by the prosecutor, the procedure for the insurance of warrant of arrest by the judge shall be governed by paragraph E of this section. When the investigations is conducting by judge himself, she shall follow the procedure provided in the section 3 of this rule. If his findings, the recommendations are affirmed by the provincial or city prosecutor or by ombudsman or his deputy, and the corresponding information is filed by we shall issue a warrant of arrest, however, without examination in writing and other out of the complainant and his witnesses in the form of searching questions and answers, that a probable cause exists and that there is a necessity of placing the respondents under immediate custody in order not to frustrate the ends of justice. When a warrant of arrest not necessary, warrant of arrest shall not issue of the accused in all already under detention pursuant to a warrant or issue by the Municipal Trial Court in accordance with the paragraph B of this section, or if the complaint or information was filed pursuant to section 7 of this rule, or is for an offense penalized by fine only, the court shall then proceed in the exercise of its original jurisdiction. Section 7. When accused lawfully arrested without warrant. When a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation, the complaint or admission may be filed by the prosecutor without need of such investigation, provided in case has been conducted in accordance with existing rules. In the absence of or unavailability of an in-case prosecutor, the complaint may be filed by the offended party or a peace officer directly with a proper court on the basis of the affidavits of the offended party or assisting officer or person. Before the complaint or information is filed, the person arrested may ask for preliminary investigation in accordance with this rule, but he must sign a waiver of the provisions of Article 125 of the revised Penal Code as amended. In the presence of his counsel, notwithstanding the waiver, he may apply for bail, and the investigation must be terminated within 15 days from its inception. After the filing of the complaint or informations in court without a preliminary investigation, the accused may within 5 days from time he learns of its filing ask for preliminary investigation with the same right to adduce evidence in his defense as provided in this rule. Section 8, records. E. Records supporting the informations or complaint. Information or complaint filed in court shall be supported by the affidavits and counter affidavits of the parties and their witnesses, together with the other supporting evidence and the resolution on the case. B. Record of preliminary investigation. The record of the preliminary investigation, whether conducted by a judge or a prosecutor, shall not form part of the record of the case. However, the court on its own initiative or on motion of any party may be order the production of the record or any of its part when necessary in the resolution of the case or any incident therein, or when it is to be introduced as in evidence in the case by the requesting party. Section 9. Cases not requiring a preliminary investigation nor covered by the rule of summary procedure. E. If filed with the prosecutor. If the complaint is filed directly with prosecutor involving an offense punishable by imprisonment or less than 4 years, 2 months, and 1 day. The procedure outlined in Section 3 E of this rule shall be observed. The prosecutor shall act on the complainant based on the affidavits and other supporting documents submitted by the complainant within 10 days from its filing. B. If filed with the municipal trial court. If the complaint or information is filed with the municipal trial court or municipal circuit trial courts for an offense covered by the section, the procedure in Section 3 of this rule shall be observed if within 10 days after the filing for the complainant or information, the judge finds no probable cause after personally evaluating the evidence or after personally examining in writing and under oath the complainant and his witnesses in the form of searching questions, answers, he shall dismiss the same. He may however require the submission of additional evidence within 10 days from notice to determine further the existence of probable cause. If the judge still finds no probable cause despite the additional evidence, he shall within 10 days from its submission or expiration of said period dismiss the case. When he finds probable cause, he shall issue a warrant of arrest or a commitment order if the accused had already been arrested and hold him for trial. However, if the judge is satisfied that there is not necessary for placing the accused under custody, he may issue summons instead of warrant of arrest.